vary slightly, but that manual that we'll have Kelly distribute should give you all of that local contact information. I'll walk through preventing termination, and then I'll walk through how to assist with reconnection to utilities. We'll touch a bit on other relief that's available for victims of domestic violence in the utility context. I'll make sure you have the resources you need in case somebody needs to dispute a bill. I'll offer some resources, and then we'll be all on to the rest of our day. So I know that this group, I likely don't need to go into this too much, but I do think it's important that we're all grounded in the same definition. And maybe that's just the attorney in me. So when we're talking about domestic violence, we're talking about power and control, right? We're talking about physical, sexual, emotional, economic, and physiological kinds of actions by one person against their intimate partner. And so likely that I hope everyone has seen the power and control wheel, which is really a great depiction and one I've used for years and years. And before I came to PULP and started as an attorney and then became the executive director, I worked for many years in domestic violence at the Pennsylvania Coalition Against Domestic Violence. And so my training is really rooted in this power and control wheel, right, with all of these different forms of abuse. And the one that we're going to focus in on, because it's utilities, is economic abuse, right? And so when there is power and control, there's going to be various ways of using economics to control the person. And so economic abuse comes up in so many different ways. But for our context, accumulating debt, forcing somebody into bankruptcy, denying access to finances, not allowing someone to work outside of the home, causing, repeated absences or causing them to lose their job. Use of children also becomes part of the equation when utilities are involved. Because you can't oftentimes remain the custodial parent if you don't have the ability to turn utility service on in your home. Same with housing, right? If you can't access utility service, housing becomes a problem, both in obtaining public housing, because if you have utility debt that's been hanging out there, getting into public housing becomes a challenge. And so this is why all of these things are why we talk about domestic violence and utilities together, because it is a really important piece of transitioning, is making sure that utilities are free and clear, that somebody can set up new service at their home. And again, the access to public housing is huge. You can also be evicted if you lose your service. If you lose water service, your housing can actually be condemned. So even homeowners, once you get somebody to have exclusive possession, for instance, and many folks that are working on VOCA are working on protection from abuse orders. Well, what happens when you get exclusive possession of a house and your client doesn't have any money because they didn't have a job, and so they can't get utilities in their name? Or perhaps the abuser racked up a bunch of utility debt, and so you get them out of the house, but then they can't turn water on or they can't turn electricity on. And so once again, that's really why we're focusing in today on this ability to achieve economic stability. I'm going to talk a lot today about regulated utilities, and so this is an important distinction to make between regulated and unregulated utilities. Unfortunately, there just are not a whole lot of assistance available out there for unregulated utilities. Talking about municipal utilities like water authorities and wastewater authorities. And I'm also talking about electric cooperatives. So some of you in rural areas are probably familiar with, a local electric cooperative like Oliphant, if you're up north, or Allegheny County Cooperative. There are some various unregulated electric companies that operate as co-ops. we're not really going to dive too much into the unregulated world. What we're going to focus on, because it's such a big world, right? And unregulated utilities are a bit of the Wild West. If you have questions about those, you can always reach out to PULP and we can try to assist you. There really are no standard protections in that sphere. So we'll focus on where there are protections and where there is movement that you can get on behalf of your client with large electric, natural gas, and water companies. And so I'm talking about Duquesne Light for those of you in the western part of the state, PECO in the east, PPL and First Energy companies in the middle part of the state. Also talking about UGI, which has a gas and an electric company in central Pennsylvania, and Columbia Gas in the southwest, NFG, the natural fuel gas in the Erie area, and then we've got Peoples Gas in the Pittsburgh area. So I hope I've hit all of those for you. As far as regulated water, you're talking about Pennsylvania American Water, and we're talking about Aqua, and we're talking about Suez, and Pittsburgh Water and Sewer Authority. All of those are regulated utilities, and so everything I'm going to talk about applies to all of those large utility providers. So without further ado, I'll dive right into utility affordability. The first program that everyone should be aware of is the Customer Assistance Program. And this is going to vary by utility as far as what they call their customer assistance program. PPL Electric, for instance, calls it On Track, but you also may be familiar with PCAP or LIRA or CRP. All of these are what are known as customer assistance programs, and all of the electric and natural gas program regulated utilities in Pennsylvania offer a CAP program. The primary benefits of CAP are, one, a discounted bill. So based on your level of income. So depending on where you are in the poverty scale, you'll get a varying discount. And all of those discounts are structured a little differently. Some are called credits, some are called, are straight discounts, but the discount component is always going to be a part. The second benefit, which is a huge one, is arrearage frozen past due debt and arrearage forgiveness. These are kind of together. And so when you enter the CAP program for the first time, any debt that you had before you entered the program would be frozen and eligible for forgiveness over time. So each time you make a payment on your discounted bill, a portion of the debt that you entered the program with is forgiven. The time period for that forgiveness varies. Sometimes it's 12 months in some programs. PECO, for instance, in Philadelphia is a 12-month arrearage forgiveness time frame. PPL Electric, for instance, has an 18-month time frame. And most of the other utilities have either a 32 or a 36-month time frame for forgiveness. But that component is a big one. General eligibility, though there is one exception I'll note in a moment, is income no greater than 150% of the federal poverty guidelines. Actually, and this I needed to update, there is no longer a payment troubled requirement. So it used to be that some of the utilities imposed a requirement where you couldn't enroll and get this discount until you were actually behind on your bill. That is no longer a requirement. So basically, anybody you're working with who is currently, while you're working with them, at 150% of the federal poverty guidelines or below, I would refer them to enroll in CAP, because there's no reason why they shouldn't start getting this discount and making their bill more affordable. And if there are any questions, again, I invite you to type them into the chat box. I am trying to make up a little bit for lost time. So do, stop me if I'm going too fast or if you have questions. The next program I'm going to touch on is LIHEAP. And LIHEAP is a big component. And so you've probably seen a lot about the Recovery Act program through LIHEAP, and I'll touch on that in a moment. But first, with the standard LIHEAP program, essentially the window is generally November through April. And so the normal program is closed right now. And again, I'll get to the Recovery Act program in just a moment. But the three components of the standard LIHEAP program are: one, a cash grant. Now this is available every year. So every year your client should be referred. This is money in their pocket if they have income at 150% of the poverty level or below. They also have to be a Pennsylvania resident, and they must have a home heating responsibility. So just a little bit about home heating responsibility. And for the cash grant component, they need to either have their primary or supplemental heat. And actually, there's a definitional change coming that'll allow the secondary heating source as well to be considered heating responsibility. And so what does that mean, right? You're not utility experts. What do I mean primary, supplemental, secondary? Essentially, you can get LIHEAP if you pay for heat service directly to a utility. So this is either your electric or gas, or if you have oil or coal or wood, any propane, any of those heating sources, and you're paying directly, you have a heating home responsibility or home heating responsibility. You may also not pay directly, but you may pay as an undesignated component of your rent. And this is actually not well known, but you can still get a cash grant if you are paying for your utility service as an undesignated component of your rent. So if your landlord says heat is included, right, and that says that in your lease, you are paying through rent. It's not that your rent is just below. It is that you are paying for heat, you're just paying your landlord. The only trick with that is you will get 50% of the grant that you otherwise would have been entitled to if it's an undesignated component of rent. And this is actually an advocacy piece we've been working on. We're hoping that they'll change that policy and allow the full grant for those with an undesignated component of rent. Shelley, did you have something? Oh, I thought I heard you.
We have a question that just came in. Does immigration status affect eligibility for these benefits?
Excellent question, and I actually have a slide on it as soon as we get through the Recovery Act, so hold that question and I will get to that shortly. That is an excellent and really important one to talk about because some immigration statuses you can get, and no, it will not affect your eligibility at all. So I'll get that out of the way as a preview, but we will dig into that in a moment. So that's the cash grant. Now, the only exception to the cash grant is if you are in public housing and your heat is included in your rent, but your rent you're only paying as a proportion of your income. And this is only a small group this is going to apply to, but if all of those factors apply, you're not eligible for a cash grant. It's the only exception. With a crisis grant, I forgot to explain secondary heating source, and this is an important one, right? So whether or not you are an electric heating customer, you can generally get a cash grant and designate it towards your electric. And that's because electric is generally, unless you heat with wood or coal, generally electricity is required in order to operate your furnace, and therefore you can generally use LIHEAP to go to your electricity because it's considered a secondary heating source. For the crisis grant, so I'll move on to that component. Also a really important component, again, primary or secondary heating source, either directly or as an undesignated component of your rent. You also need to be at an imminent risk of home heating emergency. And that means you're either at risk of termination, you're already off, or if you're a deliverable fuel customer, if you have 15 days or less of fuel. And then the last requirement for eligibility is that it must resolve the crisis. So if you owe several $1,000s and the grant you're going to get is $500, it may not be enough to resolve that crisis. Now, that there is one exception there, and that is that utilities can accept less than what's owed. So for instance, many utilities have a threshold. They won't tell you what that threshold is generally, but they'll have a threshold for the amount of debt that they'll accept any crisis grant for during the LIHEAP season. For instance, PECO generally has a $3,000 balance limit, where if anybody has a balance under $3,000, they will accept the crisis grant, whatever it is, to stop a termination. The last component of LIHEAP, and this is one that's often forgotten, is that, or not known, is that they can repair or replace an inoperable heating system. As long as the heating system was operable within the last 2 years, crisis interface will come out. They have to respond within 48 hours, so it's a pretty great way to get your clients a fixed heating system. Both tenants and property owners can get crisis interface assistance, so certainly something to keep in mind. I'm going to touch on this LIHEAP Crisis Recovery Program. This is a special program run, it's funded through the CARES Act, and is in response to the growing utility debt around the coronavirus. And so this program opened on March 18th. I'm sorry, that should say May 18th. May 18th, it just opened 2 weeks ago, or I guess we're almost a month now, and it will close August 31st or until funding runs out. And we do anticipate that funding is likely to run out. There is far more utility debt right now than ever before, and we are working on addressing that. We do anticipate the funding to run out, so I would encourage you all to get your clients in as soon as possible to get this assistance. This is run only as a crisis grant program, so I already talked about the requirements for that. This crisis grant that's available is up to $800. If you receive the crisis grant during the normal season, you'll get an automatic $100 supplemental grant that'll go to households that previously received a crisis grant during the regular program year. Those households, and the maximum grant during the regular program year was $600. So they're going to get an automatic $100 supplemental grant, and then to the extent they have any crisis dollars left between maximum $600 from before and the $800, they can get some additional crisis as well. But it is open to new applicants who are in crisis and can get up to $800. Now, for this program only, DHS is accepting a past due utility bill as evidence that the individual is in a crisis. So normally they require a termination notice, but because of the current moratorium on utility terminations, they are currently accepting a past due utility bill. There also is still crisis interface dollars available through this program. So if you know anybody that's got a furnace that's inoperable and they're income eligible, I would get them in as soon as possible to get those benefits.
Liz, I'm
yes.
sorry. This is Kelly, and for the attorneys participating, I'm going to launch the first of the question polls now. Please respond. You'll have 1 minute to do so, and the second one I will announce later on. Thank you, Liz.
Great, thanks. Well, while the attorneys are doing that, this slide has information about how to apply. I'm not going to go into detail except to say that the county assistance offices do remain closed right now, but you can still apply by mail or online. Online is going to be the fastest way to get your application processed. If a household received cash or crisis last year, they can just call that 877 number up there and apply over the phone. So important to know there. One thing I missed is during the pandemic, DHS has adopted a temporary policy that allows for self-certification. And so if somebody cannot get their documents, they can request that DHS allow them to self-certify over the phone, but they have to ask. And unfortunately, we've been working with DHS to address this, but for right now, if they're not asking the County Assistance Office to process based on their self-certification, they may be rejected if they don't submit income verification. Okay. Immigration status. I promised you I'd touch on this. Certain lawfully admitted non-citizens are eligible to apply and have no restrictions. And I'll note there is a lot of concern over how the public charge rule applies. LIHEAP is not included in the public charge rule, and so there should be no impact on an individual's status if they do apply and receive LIHEAP. So I would encourage anybody that's working with immigrant communities, first of all, if they're eligible non-citizens, they should just apply. Even if they're ineligible adults in the household, they may still apply. There is no restriction. They would just mark themselves on the application as a member of the household, and they would check the ineligible box. This would allow the DHS office, essentially then they would include that adult in the calculation of household size, or I'm sorry, they would include the income for the purpose of eligibility. So the ineligible adult's income would count, but the individual in terms of household size would not count. So if you had a household of 4, 2 were lawful citizens, or, you know, eligible citizens under here, and 2 were undocumented individuals. That household would declare the income for those 2 ineligible applicants, and they would, so it would be a household size of 2, counting the income of all 4. And I hope that makes sense to folks, but if you do have questions, type it into the chat box. And I'm going to keep moving unless we get questions.
Liz,
yeah.
we do have a question.
Great.
Where to find FPIG guidelines?
The Federal Poverty Guidelines. I find them the old-fashioned way, typing it into Google and pull up a chart. But we will share with you the LIHEAP flyers that we created that have a little cheat sheet for who's eligible. And generally, you can find that information on the HHS, the Department of Human Services, the federal government, their federal income poverty guidelines. Another important program to keep in mind are hardship funds, and most of the regulated utilities, both electric and gas and water, operate a hardship fund, which will provide a cash grant to resolve a utility crisis. There are sometimes recent payment requirements, but the utilities will make exceptions to these. So, you know, they'll say, you're eligible for a grant if you've made payments of X amount over the last several months. They will waive that, but you have to ask and explain why. And generally for a victim of domestic violence, it would be useful to ask because utilities will often comply. There are, and I'm not going to get into this, but you should be aware that there are energy efficiency programs that are run by each of the utilities. So if somebody has extremely high usage and high bills, there may be some assistance. So keep that in mind if you're working with someone and learn that they're paying, you know, some outrageous rate for utility service. It may be that they have really inefficient, you know, home where they could get some services. And this can do some pretty extensive work in homes. It's available to tenants and to homeowners.
Liz, if I could
yes.
just interrupt, I'm sorry, we have a question. Just to be clear, the income for undocumented folk will be used, and in your example, the income will be used for a household size of 2, parentheses, eligible residents.
Yes, exactly. So the income of undocumented folks count for the the income of the household, but they do not account for the determination of household size. So you are exactly right in the way that you rephrased it. Yes. Great, that means I've communicated okay. I'm going to move us into preventing termination, because this is really important, right? And so right now, for the regulated utilities, there is a mandatory moratorium until September 2nd, or until the Commission acts to change their order. Right now, the moratorium on utilities is tied to the Governor's proclamation of emergency disaster, and so that was renewed on June 6th until September 2nd. So after that, utilities may start to terminate. Now, this is regulated utilities. I did mention there are all those unregulated utilities that are not subject to the mandatory moratorium. Thus far, we've worked with the associations that kind of corral all of those unregulated utilities, and we've gotten lots of assurances that they have no intention to begin terminating. Though if you find that your clients are starting to be terminated, certainly do let us know, because right now we're under the understanding that nobody is currently moving to terminate utility service. Authorized termination. So generally, right, there will be a time when utilities will begin to terminate again. So it's important to know what's going to happen, right? First is they can be terminated for any number of reasons, but non-payment and failure to complete a security deposit or to allow access to the meter, all of those things can result in a termination. Terminations can only occur Monday through Thursday. This was a win that PULP and others had a couple years ago, where we got them to eliminate Friday terminations, so that there's a little more time to assist somebody, right? So they're not shut off Friday afternoon and going to be off all weekend. Even if the termination notice has a Friday on it as the first date that they'd be eligible for termination, they wouldn't be able to proceed with that until the following Monday. Now, holidays are not always a guarantee that there won't be terminations. Most utilities do work on holidays, but some don't, so that may be something. There is one exception to note, that victims of domestic violence, if they have a protection from abuse order or they have some other court order that indicates that they're a victim of domestic violence, has to be a court order. So the question always is, what is a court order? I'll get to that in a moment. But they can't be terminated for non-payment of residential service in somebody else's name. This becomes a very important exception when you're working with a victim of domestic violence, particularly during transition, who is trying to get service established in their name, or is trying to prevent termination based on their batterer's debt. They cannot be terminated for the batterer's debt. They also cannot be forced to pay their batterer's debt if it wasn't accrued in their name. Now, it doesn't help folks who were forced to put all the stuff in their name and then, the batterer never paid, even though they said they were going to. There's lots and lots of reasons why this exception is not going to meet all of our clients' needs. But generally, a victim of domestic violence with a PFA or some other court order may not be terminated for payment for service in someone else's name. The general rule is, though, if you live in a home with someone and you're an adult, doesn't matter whose name it is, service will be terminated. So it is a very good exception and one to certainly be aware of. Notice requirements. There are generally 3 big notice requirements. There is a 10-day written notice. Now, important to note that it must be provided at least 10 days before, but it is good for up to 60 days. So oftentimes people reach that 10-day mark and go, well, nobody came to terminate me. I'm probably fine. Something happened. I guarantee you nothing is fine and nothing happened. Nobody magically took care of that bill. They will terminate at some point. It's just they have up to 60 days to act on that termination. They'll also get an attempt to make personal contact. And this is 3 days prior to the termination. But personal contact, just like everything in the law, doesn't actually mean what it says. It means an attempt to make personal contact by phone or in person. It does not mean that they've actually contacted the person. So they may call at various times of days, 2 days in a row, and they deem that acceptable attempt at personal contact. A thing to watch out for is that sometimes clients sign up for electronic notices and then they change their email or they don't have internet access, and so they can't access that notice. So, important piece is to make sure that they withdraw that permission and get written notices if they don't have internet access or access to their email. If somebody has a PFA on file, they're supposed to get one additional notice 48 hours prior to termination. So I advise clients, just like they tell their school about a PFA, you should send a copy to your utility. And that way they'll know that they're supposed to give you additional notice. They'll also know that they're not supposed to charge you debt that accrued in somebody else's name. And they know to treat your account a little differently than other accounts, in a good way, not a bad way. So the different strategies for preventing utility termination, I already talked about the assistance programs. This is the very first line of defense, would be to get them enrolled in CAP, which has arrearage forgiveness, to get them a hardship fund grant, or to get them a LIHEAP grant. Those assistance programs are critical, and I would advise you to get all of your clients in them if they're income eligible. Protections for customers with a PFA. I already talked about how they can't be charged with debt accrued in someone else's name. They can't be terminated for debt accrued in somebody else's name. So essentially they can get a new account set up in their name if that happens, and they'd be free and clear, and there should be no transfer of debt. Promised I'd touch on what other court orders means here. And essentially it could be any type of order. I would encourage you to be creative. I have used bail restrictions. I have used no contact police orders. I would suggest perhaps a custody order that has some evidence that there's domestic violence, charging documents if they're signed by a judge. Any of those types of alternative orders that you might see in your normal day-to-day may be enough to get them these additional utility protections. If you have a wonky case and you're not quite sure, give me a call. The payment arrangements, and I'll touch a little more in depth on this in a moment, though I note that because we got started late, we're going to have to skip through some parts. So I will skip through some of that payment arrangement stuff. Essentially, you can get a payment arrangement either from the utility, or if the utility refuses, you can get one from the PUC. And the length of those arrangements are set. So generally, someone can get up to 5 years if they're at at or below 150% of the poverty guidelines. A little bit shorter as you go up the income scale, but payment arrangement is certainly an option. And again, for victims of domestic violence with a PFA or some other court order, they may have the opportunity to get additional longer payment arrangements that aren't constrained by those time limits. There are medical certificates as well that can temporarily prevent a termination. I won't go in depth into that. We just don't have the time, but that is an option. It's not the best option because it delays termination. It doesn't resolve the underlying debt. Again, those assistance programs that are going to actually resolve the debt are far more are a far better approach, but certainly if you're just trying to buy someone a little time, a medical certificate may be an option. The winter moratorium, that's every year. It starts December 1st and runs through March 31st, and any heat-related service cannot be terminated. So electric and natural gas and any water heat-related service. So if somebody has radiator heat that requires water, they would be protected under the winter moratorium. If somebody's already off as of December 1st, it does not guarantee that they'll be turned back on. Every year, we unfortunately have over 20,000 households in Pennsylvania that we know of that are off when the moratorium begins. And unfortunately, they often remain off all through the winter without heat. So it is, not a fail-safe. It doesn't guarantee that every household has heat in the winter. And then the other thing to be wary of, and I see this a lot in the domestic violence context, is the 4-year rule. And so phantom debt can come back onto somebody's bill. Perhaps they moved in with a batterer, they had debt from an old place, they're now moving out, getting a new apartment, they may have debt that follows them and prevents them from reconnecting. If that debt is more than 4 years, it cannot be the basis of termination, and it cannot prevent them from reconnecting. I touched on payment arrangements. For the sake of time, I'm going to skip right through those, but we will be sharing these slides so you have all of that information. Medical certificates as well. Generally, a medical certificate will stop termination for 30 days. They can be renewed 2 times for a total of 90 days protection as a matter of right. But if throughout that time that they're protected by a medical certificate, they keep up with their new current charges, regardless of the old debt that they had, if they pay their new charges, they can continue to renew a medical certificate beyond the first 3 certifications. So something to keep in mind, again, as a delay of a termination, but it doesn't resolve that debt. Some strategies, and I'm really speeding up here because I want to get to a couple more slides, but connecting and reconnecting service. Many of the same strategies as preventing termination apply when you are trying to reconnect service for someone. So no security deposits for CAP eligible households. That is a big one. If they are eligible, meaning their income qualified at 150%, the poverty guidelines are below, the utility must waive the security deposit. Again, there are those protections I touched on for victims of domestic violence with debt that was accrued in someone else's name. It cannot be transferred to their new account. There's the 4-year rule that applies here too. They can't be prevented from reconnecting if their debt is more than 4 years old. They can get access to a payment arrangement either from the utility or the PUC. And again, those are prescribed timeframes when you're getting a PUC arrangement, but they can be longer if it's a victim of domestic violence with a protection order. And we've gotten things up to 10-year payment arrangements in some cases for victims of domestic violence.
Liz, we have a question. What utilities may require security deposits?
So that's a great question. Utilities, generally any utility may require a security deposit, either for existing customers who have been payment troubled or for new customers. They cannot charge us the security deposit and so for regulated utilities, if it's somebody is low income at or below 150% of the poverty guidelines and are eligible for CAP, they cannot be charged a security deposit. So if you're working with anybody who is, they may assess it, right? And the person will need to provide proof of income. They must waive it once that's provided. The unregulated utilities are not subject to this, this restriction and can charge a security deposit to anybody. A couple of important other protections, particularly for victims of domestic violence. One, third-party notification. So if somebody's mail is being messed with and they're not getting notices, they may want to set up a third-party notification so that it goes to somebody they trust or even a domestic violence agency that they're working with. Those can be very important in making sure that the survivor knows whether or not they're being switched, for instance, to a competitive supplier, or if they're at risk of termination, or if there's some other notice that the utility needs to send to them. The other important thing is account passwords, and we have had instances of some pretty severe batter intervention and abuse using the utilities. I had a client a couple years ago who worked second shift, and when she got home in the middle of the night, the utility had come out and shut off her gas service in the middle of winter. The batterer had gone and cleaned out her house of all her furniture, opened up the windows, and the pipes froze. And so that was because the batterer was able to contact the utility and access the account, because he still had knowledge of the account information. So setting up an account password, particularly if you're working with somebody who has a batterer that is using those kinds of tactics, would be a really important thing. And they can set up a flag on that account so that information doesn't get out. Account activity notices likewise can happen, so that if there are changes on the account, like trying to change the people on the account or who can access it, that the victim will be notified. A really important thing, and I do recognize that we are at 11:02, and so Kelly, I want to ask, can we continue to go through to make up for that time in the beginning? I want to make sure we're fulfilling the CLE requirements, but I also want to release anybody that really needs to go.
I'm fine with continuing. However, I would just say, at least on my end, your audio was perfectly fine throughout everything since the beginning, but just in the last 30 seconds, it started sounding a little choppy again. So attendees, can you let me know if you're hearing okay? Can I get feedback from someone in the chat box just to let me know how you're hearing things?
Oh, good. I see a lot of I'm fines.
Yeah, so maybe it's something with me being the facilitator. I'm happy to have you continue. I think we started about 11 after, so I'm happy to have you do the full hour.
Great. Well, I'll keep going for those of you who want to continue. I did see somebody say, please continue. So we'll get going on some of the other relief.
Actually, I'm sorry. I'm going to go ahead and launch the second poll question for attorneys participating for CLE credit. Please respond to this. It'll be up for 1 minute. And Liz, feel free to continue and get your full hour of information in for everybody. Thank you.
Well, wonderful. And thanks, everybody. So requesting utility relief in a PFA, and it's been many years since I've practiced in the PFA context, but it is an important piece, and I know a lot of you work with judges who just won't consider the economic components of the relief that's available under the PFA order. But I will tell you, particularly when you're working with a client whose bill was in the victim's name, they do have the different types of program assistance that we can help deal with debt that's been accrued in their name, or perhaps they have old debt from before the relationship that they're trying to deal with. There's not a lot out there apart from what we've worked with or talked through to address that. So this provides perhaps another option to use 61088 and to say, utility debt is an out-of-pocket loss, or if it's related somehow to moving expenses where they're going to have to pay upfront costs to address old utility debt to get their service connected, certainly I would say start requesting it in your PFAs. Start requesting that the batterer change service over to the victim's name, or that the batterer keep service in their name and pay for that service. The circumstances are going to be different, and the situations are going to be different for what your clients need. But I would talk to them about what happens to the utility service when we get this PFA. If we get him evicted and excluded, and I'm using him because the vast majority of batterers are men, this is not a recognition it's acknowledging that men are also battered, but if there is a batter who's evicted and excluded from the home. Have you addressed what happens to that utility service? And so, yes, there's all this utility relief and options to do it through that context. But if we start getting utility relief and addressing it in a PFA, you may prevent the victim from ever having to go through that hassle, and you may even get some losses that the victim has sustained in terms of utility relief. PUC dispute process. So I'll spend a moment on this because it is important. I will say 99.9% of the cases, individual cases that we handle, are resolved by negotiating directly with the utility. Utilities are motivated to not have formal or informal complaints be brought against them, and they're particularly motivated to resolve issues for victims of domestic violence. And so negotiation directly with the utility before filing a complaint often just resolves it, and you can get an awful lot of things. For instance, if you're working with a victim and trying to get them into public housing, but they have utility debt, we've been very successful with many of the utilities at getting them to allow the victim to set up service without paying on their old debt and get enrolled in CAP right away. So that is one way, you can then work with the housing authority to say, nope, we have a plan to address that debt. This is related to their victimization. The housing authority can then say, okay, well, we'll let them into the house, in which case they can get an address, in which case they can get service established, because oftentimes the problem is the housing authority is saying, you've got utility debt you need to deal with. The utility is saying, until you have an address, we can't put you in any program to give you assistance to deal with that. And so you have a chicken and egg problem. But negotiating with the utility can often resolve those kinds of common issues that come up when we're trying to get housing assistance to folks. Utilities also have significant discretion, which is what makes that negotiation effective. And I would always just kind of ask and be direct with the request. And I can help you with that, and others on PULP staff can help you with that. So I would say if you're working with a victim, first couple of times it's going to be a little like, I'm not sure who to reach out to at the utility or how to do this. Do reach out to us and we'll teach you. And then, from then on, it's a pretty routine thing. It can boost your case numbers and it can really boost outcomes. We have cleared, over the past several years, since we've been focusing on the intersectionality of domestic violence and utilities, we've cleared hundreds of thousands of debt off of victims' bills. And so it's pretty easy to do. And I would encourage you all to start addressing utility debt with your clients, because it's a great way to help overcome some of the financial barriers to establishing a safe home. If it does become a situation where you can't resolve the complaint, and there's always these, right? There's always these tricky situations. There is an informal complaint process, and that is a pro se process. So it allows anybody can just call that 800 number on the slide and file an informal complaint. That will temporarily stop the termination as long as it's filed at least the day before the termination is set to go through. It's a good way, and as long as it's a legitimate complaint and not just one solely for the purpose of delay, it's a really good way to get somebody some fast relief, stop the termination, and that often also provides you the time to negotiate and figure out a solution with the utility. And then if it becomes necessary, there is a formal complaint process where that would go before an administrative law judge. A couple of resources here. We do operate a very small utility hotline for those who are in imminent risk of termination. Please, please, please don't just refer all of your clients there. We are a very small organization. We handle about 500 cases a year through there. But if there's an issue that you really can't deal with, again, we provide a lot of technical assistance. So I would say call us about it if you are able to resolve it. If not, you can refer to our hotline. We just ask that you not refer everybody, or else we'll quickly be overwhelmed and not be able to keep up. If you are working with somebody who's not low income but is facing a utility issue and who might not be eligible for our services are available up to somewhere around 200% of the poverty guidelines. But if you are working with somebody who's got a bit of resources but who has an issue, the Office of Consumer Advocate serves all residential customers, so you could refer them there. And then, of course, if you work with the local legal services program, many of the local legal services programs handle utilities as well. And that, so we did get through all the information in an hour. I know I rushed through a couple of things, so I want to give space if there are some questions or anything like that that folks have about the information. I will be sending, again, the PowerPoint to Kelly, and I have to make one edit to that, so we'll get that out to you today. We have some LIHEAP flyers that can go out to others, both in English and Spanish, about the LIHEAP Recovery Act program, so we'll have that available. And we have a advocate manual that we'll send to you that has all the local contact information for you, utility assistance programs, as well as a kind of how-to and question and answer format about how to address the most common issues that we talked about today. So thanks, everybody. I'm not seeing any questions, but Kelly, did I miss any?
No, I haven't seen any others other than the ones that you've addressed.
Okay. Well, then I will get that information out to you to send out to everyone. And I am so sorry about the audio problems this morning. I'm glad that we were able to pull all this together. So have a great day, everybody. I hope the rest of your VOCA trainings are wonderful. And please do reach out if you run into any utility issues in the field.
Thank you so much, Liz. We appreciate your presentation and all the information you shared. I know that usually at our in-person VOCA trainings, the evaluations show that everyone really values this information, and a lot of people weren't aware of some of it. So I thank you for helping us get the information out there.
Sure thing.
You have a great rest of the day, everyone. Thank you so much.